And welcome to Employment Law Show. John Scholes, Lior Samfiru. We are right back at it, giving you the great employment knowledge, the place where you spend roughly 8 hours a day for 30, 40 years of your life. So you got to know what's going on. You want to have a beat on all this. So we're going to give it to you, and we do every week on the show. By the way, you want to follow along or follow up with a phone call, rather, 1-855-821-5900. Employmentlawyer.ca is the website where you can catch past radio shows. We'll get to some of those calls, as we always do. And if you put a help in front of that, help@employmentlawyer.ca, you can reach out anytime through email. So we'll get to all of that today, including situations that trigger employment law disputes. That will be the topic a little later on in the show. Brother, always get to the week that was. What's going on?
Hey, John, it's great to be back. Great to be talking about employment law. You know, when it comes to employment law and your workplace rights, Google is not your best friend. Ooh. When it comes to many other things, yes, Google, I do it, you do it, we go on Google, find out what we need to know, but not when it comes to your employment law rights. It's more nuanced than that. You really have to know what you're looking for and what information to seek. So that's why we are here on TV, we're on radio as well. We're all over the place to try to give you the right information about your workplace rights to solve, hopefully, your problems and inform you and arm you with the knowledge you need to have if you have a job, if you lost your job, if you're going to accept a new job. All that information, it's so, so important. And you spend, as John said, so much time at work. That information governs what you do at work where you spend most of your time. So you need to have it. And if we don't cover the topic or the question that you have, not a problem. Call me at the office, email me. We'll give you that contact information throughout the show. There really is no reason why you don't reach out with your questions. We make it easy. But week there was, John, let me tell you about a situation that came across my desk just to kind of get us warmed up for this show. So I spoke with a gentleman who had been off on a disability leave for about a year and 10 months or so. He had a serious back issue. It was getting better, but unfortunately it was getting better very slowly, not as quick as he had wanted to. Had been in touch with his employer, was receiving disability benefits through the workplace plan that he has, cooperated with the insurance company anytime they needed something. He sent them that information. He went to independent medical exams, was the model employee in terms of how responsive he was. All he wanted to do is get better, get off disability, and go back to work. Well, wouldn't you know it, he gets a letter from the insurance company, says, we think in a couple of months you're able to go back to work, so we're going to be cutting you off, and wish you all the best, and that's it. So as he's dealing with that, literally he's deciding to write a long letter to the insurance company telling them why they're wrong. He gets another letter, or I think it was an email from the employer saying, oh, we heard the wonderful news. You're able to come back to work, so we expect you to be back to work on this date. And if you don't come back to work, we'll just assume you've resigned. Holy cow. Mm-hmm. He still can't work. He's still dealing with a serious back condition. Now the insurance company says, you're not going to get paid anymore. Oh, and his employer is saying, if you don't come back to work, you're done, you're gone. Terrible situation. And as terrible as that sounds, for many of our viewers, they would have never seen something like this. It is common. It is very common when someone is on a disability leave, they're getting benefits from the insurance company, they get threatened to be cut off, and then the employer says, we're going to let you go or consider you to have resigned if you don't come back to work. Well, he called me and I spoke to him. So here's the thing. If he can't work, then his insurance company should continue paying him. If his doctor supports him saying he cannot work, the insurance company is wrong to cut him off, despite what they may want to do. And if his doctor says he can't work, then his employer can't expect him to come back to work. So, and those are two separate things. So I connected with him, connected him also with another member of my team. We're going to help him on both fronts. We're going to help him get the benefits from the insurance company so the insurance company doesn't cut him off, but also we're going to deal with his employer, get his employer to back off. If you're ever in that situation, your doctor is judge and jury when it comes to your ability to work. Your insurance company should listen to your doctor, and certainly your employer should listen to your doctor. If your doctor says you cannot work, that's it. No one else should question that or interfere with it. If that happens to you, you know what to do. Reach out to me. I'll help you out.
And it is worth mentioning as well that the other half of the firm with your partner, Savan, who does a disability law show right here, is the fact that you guys have both under one roof, and because there's so much interplay between the two all the time, It's the best way to go, right?
Like this situation. Insurance company cuts you off, your employer's threatening you. That interplay happens all the time. We deal with both of those issues, and that's exactly what we're going to do for this person and for many others that have contacted us all the time.
Employmentlawyer.ca, that is the website. Go there, find and listen to past radio shows. We take the calls from the shows and we talk about them on here. Phone call number 1 for today is right now.
I'm in management at my particular company, and when I took on that role, I was contract slid across the table. Within that contract, it basically said any of the things that constitute constructive dismissal, change of geographic location, scope of the role, pay, hours, you name it. If that happens, it does not constitute constructive dismissal. I obviously signed that contract not wanting to rock the boat and get a black eye on my career because they just go on to the next person. When and if a scenario like that occurs for me later on down the road, do I have any leg to stand on?
So our regular viewers know that a change to the terms of employment, a significant change, is a constructive dismissal. Generally, your employer cannot change your job duties, your hours of work, your pay, your responsibilities. If they do, you can treat that as a termination, treat that as a constructive dismissal. Except, John, it's not a constructive dismissal if you signed an employment agreement giving the company the power to do that. Right. So if you sign an agreement saying to the company, you're allowed to change my job, and then they go and change your job, well, it's not a constructive dismissal because they're only doing what you've agreed to allow them to do. So that's why it's so important to know what we're signing. Think about it. This person essentially signed a job offer saying, you'll hire me for whatever position you want, give me whatever responsibilities you want, and I don't have any say in it. What's the point of even accepting a job if the terms are, you'll hire me on whatever basis you want, just do whatever you want with me? Most employers won't do that, but if you are offered a job offer letter, an employment agreement that allows the company to change your pay, change your hours, change your duties, be very careful. Then it's not a constructive dismissal if they do that. So this person, based on that description, appears to be stuck. That's why you don't want to have an employment agreement. You're better off to work on a handshake. And if you do sign an employment agreement, be very careful as to what it says. If you're not sure what it means, if you're not sure if it's problematic, reach out to me, let me review it, and let me tell you if you should be concerned.
Phone number again, 1-855-821-5900 anytime. Another wonderful, wonderful resource, pocketemploymentlawyer.ca.
So, John, I wanted to make sure that everyone has access to information all the time, wherever they are, whenever they need it. So I created pocketemploymentlawyer.ca. So guess what? You already have an employment lawyer. You already have your own me with you on your phone, on your tablet, desktop, what have you. You simply go to pocketemploymentlawyer.ca, pick the category that you want to find out more about your rights, and that's it. Get answers to your questions. Maybe you've just been let go and you want to know how much severance you're owed. The very first place you go to is pocketemploymentlawyer.ca. It's going to calculate the severance that you're owed. If you want to find out if you're an employee or an independent contractor, go there, answer about 3 questions, find out. Same thing if you want to find out if you've been constructively dismissed. Maybe it's a situation of workplace harassment or discrimination. Answer those questions, get that information. It's free. It's anonymous. You don't have to put your name or the company's name. You can use it and then turn it off and move on if that's what you want to do. Or if you want, you can contact me directly from pocketemploymentlawyer.ca. Before you even call a lawyer, go to pocketemploymentlawyer.ca.
Got an email here from Charlotte. We want to read this email and run it through the Pocket Employment Lawyer to give you an example how it works, how effective it is. Charlotte says, I was dismissed with cause from work last week. I'd been given permission by my employer to take an unpaid week from work to look after my sick mother. When I returned, my boss accused me of lying about the whole thing, fired me. I worked there for 2 years.
So, a situation I've come across before. You get time off, it's approved, then the boss says, oh, we don't think the reason you gave us was legitimate, so you were lying, you were being dishonest, so we're going to let you go. Now, let's take it a step at a time. Frankly, even if she was being dishonest about this, not a good thing, but probably not cause for dismissal. One incident is almost never cause for dismissal, which means she's been wrongfully dismissed. But let's find out in this particular situation if it is really cause. So I can, of course, tell you, but pocketemploymentlawyer.ca can also assess that in seconds. So let's run this through pocketemploymentlawyer.ca. First question would be there, how long did you work for the company? 2 years in this case. What were you accused of? In this case, it's dishonesty. Did, in fact, do what your employer alleged? She says she did not. and she wasn't disciplined before. Well, guess what? PocketEmploymentLawyer.ca correctly says, since you didn't do what your employer says that you did, there is no cause for termination. And therefore, you're going to be owed severance. Absolutely. It's that easy. If you didn't do something you were accused of, you have to be paid your full severance. Even if you did do something wrong, chances are it's not cause. Chances are you're still going to be owed your full severance. PocketEmploymentLawyer.ca is your friend.
Situations that trigger employment law disputes. That little nugget is coming up after a short break. Reaching out, 1-855-821-5900, employmentlawyer.ca. It's the Employment Law Show. Stick around, coming right back.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Employment Law Show. John Scholes, Lior Samfiru. Our topic for today, what we're going to talk about now, is situations that trigger employment law disputes, right?
So we talk often about, losing your job and severance. It's probably one of the most common things, and not the most common thing that I deal with. Someone's let go, they're not offered proper severance. I identify that and help them get the severance that they're owed. Call me the severance doctor, if you will. But there's many other situations that trigger disputes, trigger situations where I need to get involved and help someone. So we want to talk about some of those other than your usual severance package dispute or severance package review.
The severance doctor.
That's a nice nickname for me, right?
Turn your head and cough. Okay, thanks. First one is this: when an employee is let go while on maternity leave, even if it's for a legitimate reason.
That's right. It is a shame that still comes up, but it is something that I deal with often. I see all the time when someone is let go on maternity leave, and even if it is for a legitimate reason, remember, an employer still has an obligation to bring you back, and in many cases, they don't offer proper severance. So these maternity leave issues, parental leave issues come up all the time. And the rule is so simple. I don't know that it could be any simpler. If you're taking maternity leave, a parental leave, you cannot be let go. Full stop. I don't know how much clearer I can say it. You cannot be let go. What has to happen is you have to be brought back to the same job, same position, same pay. And, maybe one time I'll say, you know what, John, this is now a rare occasion that I need to deal with these situations. It's a common one. If your employer does anything to you while you're on maternity leave or a father on parental leave, reach out to me right away.
Again, situations that cause employment law disputes. This one we get all the time on the radio show, and that is when an employer tries to call somebody an independent contractor, and they're doing it to save money.
Of course they're doing it to save money. They're doing it to save a lot of money, but it's not that simple, and it's not legal. And individuals get misclassified all the time. They're called an independent contractor. They sign a paper that say that they're an independent contractor. They pay their taxes as if they're an independent contractor, except they're not. They are employees in the eyes of the law. Happens all the time. So how do you know? Well, you can always go to PocketEmploymentLawyer.ca, but generally, if you have a regular job, you work for a company, you do the job, you come back home, you spend a nice evening with the family, then the next day you go back and do the same thing. You have a job. You are an employee. It does not matter what you signed. It does not matter what you call yourself or what the company calls you. The law decides. Now, when it comes to an employment dispute, oftentimes we see the dispute happen when this supposed contractor is let go. Company says, well, you're a contractor.
No severance.
We don't have to pay you anything because you're a contractor, except they're an employee. And because they're an employee in the eyes of the law, they get full severance, full compensation. And then there may be the issue of unpaid overtime and vacation pay and holiday pay. So if you've been misclassified, you gotta be mindful of that. You gotta understand that you have rights, and that's especially gonna be important if and when you're let go because you're owed your full severance.
Reaching out, by the way, anytime, 1-855-821-5900, help@employmentlawyer.ca. The times that trigger employment law disputes, the next one's this, and we talked about this the other week in the show, when an employee is terminated right before that bonus is due.
What a brilliant move. We know what to do. Yeah, we got to pay someone a $50,000 big bonus, but if we let them go before we pay, we just save 50 grand. No, it does not work that way. The law is smarter than that. If it looks like you let someone go to avoid paying them what they're owed, number one, you're going to have to pay them what you owe them. That goes without saying. But because you thought you were so smart, because you try to get away with avoiding paying someone, you're going to have to pay extra. Bad faith damages, maybe punitive damages, because the law doesn't like that. The law doesn't like the more powerful party, the employer, trying to put one over the employee. It's not something that's acceptable. So I've been involved in dozens, if not hundreds of matters over the years where the employers refuse to pay someone an amount that they're owed because that individual was let go before that happened. It doesn't work that way. You still have to get paid everything you're owed. If you're not sure what you're owed, if you're not sure if what the company did is right or legal, reach out.
Or pocketemploymentlawyer.ca is also a good place to go, right?
Easy, anonymous, free. And if it's midnight and you need answers to your questions, just pocketemploymentlawyer.ca.
Again, triggering disputes. This one, when an employer resorts to termination for cause much too soon, or as you always call it, pulling the trigger way too early.
Pull the trigger way too early. John, probably one of the top 2 or 3 matters that I see. Not a week goes by where I don't talk to someone, usually multiple people, that have been let go supposedly for cause. Maybe they did something wrong, maybe they didn't, but either way, the company says, we have cause. And the reason that word, the C word, cause, is so important is because if there is cause, the company doesn't have to pay severance. But if the company says that there's cause, but there really isn't, you get your full amount of severance. That's a wrongful dismissal. It's rare. It's very rare for me to see a legitimate termination for cause. The company or the employee would have had to do something terrible, stolen from the company, committed acts of violence or sexual harassment, fraud. Those are the types of things that could mean, yes, you can be let go without any severance. In most other cases, if you are let go, the company says, here's what you did wrong. We don't have to pay you severance. Most cases, John, that's a wrongful dismissal.
Talking about situations that will trigger employment law disputes, the final one for today is simply this: when an employer lays off an employee temporarily.
The old temporary layoff, the old illegal temporary layoff, because it is illegal to terminate someone or to lay them off temporarily. And what I mean by illegal is it's a termination. The law says an employer generally does not have a right to lay someone off temporarily, at least when it comes to non-union employees. So if you've been laid off temporarily, you have the right to accept that if you want and wait and come back to work if and when the company calls you back. Or you don't have to do that. You can treat that as a termination right now and get the severance that you're owed. And a lot of what I do is I work with these individuals that have been laid off temporarily, supposedly, to get them out of there and get the severance that they're owed. If you don't do that, if you accept the layoff, you give the company the right to do it again. And the next time they lay you off temporarily, you will be stuck. So it is a common dispute, but it's an easy to resolve one. If you've been laid off temporarily, let me help you out.
Head on over anytime to employmentlawyer.ca to catch past radio shows where you can find the next one coming up here. The phone call from it, number 2 for today is coming up right now.
After 40 years of service, if the company decides to close down, would I be entitled to any severance at all? I know I'm coming up to my age now, and I believe that the company might be shutting down.
40 years, good man.
My God, a long time. So let's talk about this idea of company shutting down. A company shutting down, a company deciding, you know what, we don't want to run this business, it's not profitable, we're going to shut down. They still have to pay you severance, the same severance. Now, that's very different than if the company is bankrupt.
Right.
Bankrupt and shutting down are different things. Bankrupt means that someone forced them into bankruptcy. There's creditors that are going to take their money out. And in many cases, if there's an official bankruptcy, the employees, unfortunately, are going to be left holding the bag. They're not going to get paid their full severance. But if a company is shutting down, and God knows I've seen this hundreds and hundreds of times, they still have to pay you the full amount of your severance. No exceptions to that. So we talked about pocketemploymentlawyer.ca. Let's plug this person's information after 40 years into pocketemploymentlawyer.ca. Let's see what he's owed. So let's say he's a laborer. We see that on the screen right now. 40 years of service. he's probably not 35 if he's worked there for 40 years. So let's say he's 67 years old. Well, the pocketemploymentlawyer.ca correctly assesses him as being owed as much as 24 months' pay. Up to 24 months' pay, 2 years' pay. That's how much he's owed, even though the company's shutting down. That's how easy it is to find out for yourself. Even if you're just curious and you want to know, hey, what would I be owed if and when they let me go? Pocketemploymentlawyer.ca.
If you're working in utero, you probably could be a 40-year employee if you're 35 years
I guess,
old.
yeah.
Strange concept.
That would be somewhat strange.
Yeah, that'd be a heck of a labor law.
Yeah.
We're going to take a short break here. When we come back, how severance works for salespeople. If you're in sales, you'll need to know this if you don't know how it works. 1-855-821-5900 and employmentlawyer.ca. This is the Employment Law Show.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Employment Law Show. Time for a phone call. You want to hear these phone calls in real time anytime you go to our radio show. That can be found at employmentlawyer.ca. Phone call number 3 is right now.
I have been employed with a very well-known chip company. I started as a summer student, and I've sort of just stayed on board. I never really signed a contract, but I've been with them for 5 years. And I'm now just coming to the conclusion that they're going to lay me off tomorrow. I'm a sales rep, so I go into the stores and I fill their chips and sell them displays and stuff.
And you get paid salary, commission, both?
I get a base salary and I get commission on top of it. I am 36.
So a few things to kind of unpack here. Number one is when it comes to length of service. So generally speaking, the entire time you spend with the company counts towards your service when we calculate your severance. So maybe you started off part-time and then you became full-time. Well, all the time, including the part-time, counts towards your service. So if you were part-time for 2 years, then you're full-time for 2 years, well, now you're a 4-year employee, and that's how your severance is calculated. In this situation, she started as a summer student, eventually ended up being a regular full-time employee. Well, the time she spent as a summer student also counts towards her seniority. So remember, if you've been with the company the full time you've been with them, even if your job has changed or your status has changed, that time counts. And the more time you have with the company, the more seniority you have, the more severance you get. Now, the other situation here is that you get salary and commission. When it comes to commission, or any time that you don't have a fixed income, when it comes to your severance, we simply look at your average earnings. So if on average you make $50,000 a year, that's the figure we're going to use to calculate your severance. So we look at a 2 or 3 year average depending on the situation and use that figure. So it's okay if your salary or your compensation changes from month to month, year to year. We'll simply look at an average. So the final question, the big question for this person is, how many months' pay is she owed? For that, even I can tell you, of course, but why not just go to pocketemploymentlawyer.ca so everyone at home can see how that works. So we'll go to pocketemploymentlawyer.ca, we'll pick the severance calculation feature, and we see on the screen, she's been in a sales role for 5 years because the time she spent as a student counts. She's 36 years old, hasn't been offered severance except she's owed anywhere from 6 to 8 months' pay. Nice. 6 to 8 months' pay. 5 years, even though she's fairly young, 36, she gets up to 8 months' pay. So she's been wrongfully dismissed. If she did not get that, her whole time with the company counts. Her commission counts when it comes to her severance. If you're not sure what you're owed, reach out to me as soon as you can, or of course, anytime, 24/7, pocketemploymentlawyer.ca.
Another place to go, terminationquestions.com. Ask your questions there. They'll either be answered right away in very quick time, or there could be a chance where your question has been asked before, so there's an archive. You can search them as well. Terminationquestions.com. In that regard, Prakash says, can my ex-employer refuse to give me severance pay?
Well, that's a very broad type of a question, but generally the answer is no, absolutely not. The only time really your employer can refuse to pay you severance is if there is just cause for dismissal. In other words, if you did something so wrong, so bad, so outrageous that it's just impossible to continue employing you. Yes, then in those limited circumstances, the company can let you go without severance. Other than that, no. And what I want you to understand, and this may be what Prakash is talking about, the fact that he may have worked for a company for a short period of time does not mean he doesn't get severance. Of course he gets severance. Yeah. The fact that he may be working for a small company does not mean you don't get severance. Of course you get severance. Size of the company or the size of the company's payroll does not matter. Big company, small company, just the same, you get severance. The only time a company can say, you don't get it, is if you get terminated for cause and if it's legitimate cause. John, you and I talked before the show about an acquaintance of yours where their employer said, well, you're 65. You don't get severance.
Severance ends at 65.
We know you don't get severance past 65. Well, I mean, that's the first time I've ever heard that, but that's nonsense. Of course, not only do you get severance, by the way, at 65, you get more severance at 65 than you would at, say, at 45. Because the older you are, the more severance you get. So there's all kinds of excuses as to why a company may not want to pay you severance or may think even that you don't get severance. The only time legally they can avoid paying you severance is if they terminate you for cause, and even that, very, very difficult to do.
Again, terminationquestions.com is where you go. Chris is up this time, says, I was hired on a 15-month maternity leave contract. Only 6 months into the contract, my boss told me that I wasn't working out. I was terminated and offered 1 week's pay as severance. Do I have any rights?
Yeah, he may have some big rights, actually, and here's why. So if he's hired for a 15-month maternity leave contract replacement, that's what we call a fixed-term contract. He's hired for a fixed period of time, in this case, 15 months. Well, what's the rule with a fixed-term contract? Is if you're let go before the contract ends, you have to get paid the balance of the contract, the difference. So if he signed a 15-month contract and he was let go after 6 months, well, there's another 9 months left on that contract, which means forget about 1 week's pay. He could be owed another 9 months' pay. Years ago, I had a matter when someone signed a 5-year contract, was let go a few months into it. He was owed 5 or 4.5 years' pay. It's that important. Now, we also need to look at the actual terms of the contract. Okay. Did the company put in an exit clause or an early exit clause? So we need to look at that. But unless there is an early exit clause, if you're hired on a fixed-term contract, maternity leave replacement, you're hired for a project, maybe you're hired for a summer job, by the way. You're hired for the summer for 4 months and you were let go a month into it. You're going to be owed the balance of the contract in most of those situations. So for Chris, yeah, you're probably owed a heck of a lot more than 1 week's pay.
For someone like Chris, this is something that you definitely want to look at. If it is a fixed term, you've got to find that line in there if there's an early termination clause. Right?
Send me a copy of the contract. I can tell you in about 10 seconds flat if there is anything in there that limits your entitlements. But in my experience, in most of these fixed-term situations, that's the rule that ends up applying. You get the balance of the contract. And the company may think, hey, you only worked for 6 months. Why do we have to pay you so much? Guess what? That's the law. With the fixed-term contract, where they contract for a specific period of time, if you're let go before, you still have to get paid through to the end of the contract.
Before we go, just walk us back through Pocket Employment Lawyer quick.
So most of the things that we talk about and more, you can find out for yourself just by going to pocketemploymentlawyer.ca. And it's not about reading an article with general information about the law. I don't think that's very helpful. It's to have your situation analyzed. And that's what pocketemploymentlawyer.ca does. It allows you to find out for you in your situations, with your job, your career, your length of employment, what are you owed, what your rights are. You know, the beauty of technology allowed us to create it, and it's free. There's really no strings attached. There's absolutely no reason for the first place you go to, if you lost your job, if you have a workplace problem, for that not to be pocketemploymentlawyer.ca.
Fully bespoke. It's just for you.
Just for you.
Individual. 1-855-821-5900 is the number to reach out as well. help@employmentlawyer.ca is the email address you can use to send Lior those contracts or anything else, or simply employmentlawyer.ca is the website. We'll catch you next time right here on the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.